One more forward. All right. As of 2021, Indiana's prisons have a population of around 25,000. And this does not include the 2,500 who are residing in federal prisons within the state of Indiana. As you can see, the majority of those incarcerated in the state are not serving short sentences. I particularly want to highlight the sentence length of greater than 20 years, 33.15%. The proportion of people spending numerous years in prison is staggering, which increases the likelihood that they may require medical attention at an outside facility during their sentence. While the national state imprisonment rate dropped by 8% between 2000 and 2016, Indiana's imprisonment rate grew by 18%. However, we have seen a recent focus in Indiana to try to slow the growth of our prison population. This has been done by putting an emphasis on reducing recidivism, by modifying the sentencing structure, improving community corrections, and prioritizing funding of mental health services. So just as in our broader population, rates of chronic disease such as asthma, cancer, diabetes, heart disease, obesity, and stroke are getting higher and higher. It is estimated that approximately 16% of men and 31% of women who are incarcerated have a serious psychiatric illness. And at least 50% have a history of substance use disorder. Infectious disease, including sexually transmitted infections and hepatitis, also have increased prevalence in our criminal justice system. So this chart really says it all. In 2018, the Pew Charitable Trust took a deep dive examining how healthcare is funded and delivered in state-run prisons. What they found was that although prison populations nationally were shrinking, the number of people who were 55 or older increased by 280% from 1999 to 2016. And by 2030, it's estimated that 1/3 of people experiencing incarceration will be over the age of 55. This population, whether incarcerated or not, are more likely to experience diagnoses such as dementia, impaired mobility, hearing loss, the list goes on. However, patients experiencing incarceration typically experience the effects of aging far sooner than people outside of the prison walls due to a myriad of reasons, especially those reasons based on the previous slide, but also the stress linked to isolation and suboptimal preventative care opportunities. So I've provided a list to take just a peek at some of the ways that IU Health and our team members may become involved in the provision of healthcare for persons experiencing incarceration. This can include emergency care, inpatient and outpatient medical care, mental health care, dental, chronic, long-term, nursing home care, and hospice care. So let's take a look at a hypothetical case study. James is a 62-year-old male, currently incarcerated in state prison, serving a 5-year sentence for robbery. He has a history of advanced liver disease, cirrhosis, chronic obstructive pulmonary disease, hypertension, and type 2 diabetes. James is in the middle of his sentence, and while he was previously married, his marriage ended shortly after he was incarcerated. He has a mother and a younger brother and no children. Similar to his relationship with his ex-wife, James' relationship with his mother has become estranged and essentially obsolete. James' relationship with his brother, he's maintained pretty good contact and does have that relationship with him. Prior to the robbery conviction, James held full-time employment, shared a home with his now ex-wife, and had no prior convictions. Despite the routine medical care that he was provided in prison, worsening ascites secondary to his advanced liver disease required a higher level of care, and James was admitted to Methodist. James arrived at the hospital with a prison guard, as required by hospital policy, and was admitted to the unit. He was found to be febrile and demonstrated altered mental status. The prison guard agreed that James was not in his usual state of mind. Due to the worsening ascites, fever, and altered mental status, the physician felt that abdominal paracentesis was necessary. James did not arrive to the hospital with an advance directive, and the physician felt that abdominal paracentesis was necessary. So, like I said, he didn't arrive with an advance directive, and he was found not capable of being able to make medical decisions for himself based on that altered mental status. So although the hospital routinely cared for incarcerated patients transferred from a nearby hospital, the clinicians had mixed opinions regarding who would consent for James' paracentesis. The physician, the social worker, the bedside nurse, they were all distressed about who to contact to provide this needed consent. This was exacerbated by the assertive behavior of the prison guard, who routinely demanded that they should consent for all procedures because James was a ward of the state. So who consents for basic or non-urgent treatments and procedures? Does the patient consent? Family members? A prison warden or a correction representative? Or the physician? As you can see, this can be pretty challenging to sift through. So first, we're going to start with ethical analysis. So we are here for an ethics lecture, and what would that be without referring to the 4 basic principles of ethics? So we're going to just briefly touch on all 4. So put simply, autonomy is the ability to self-govern. Personal autonomy allows for self-rule, free from controlling interference by others that prevents meaningful choice. In healthcare, autonomy is expressed as the right of a competent adult to voluntarily make informed decisions about their own medical care following informed consent. Incarcerated patients inherently do not get to experience truly autonomous healthcare, as they often don't get to choose their own healthcare system or provider in most instances. So although incarceration inevitably places a temporary cessation on some of the rights of individuals who are incarcerated do not completely forfeit their right to self-determination. Therefore, patients experiencing incarceration with capacity maintain autonomy for medical decision-making, including consent for treatment, refusal of treatment, that includes life-prolonging treatment, participation in advanced care planning, and designation of preferences for end-of-life care. The principles of beneficence and non-maleficence play a critical role in the provision of healthcare for all patients, and this does not differ when providing treatment to patients who are incarcerated. Beneficence seeks to provide benefit and good to a patient to further their physical, emotional, and social well-being. And relatedly, non-maleficence asserts an obligation to prevent harm and to minimize the risks of harm if risks must be taken. So physicians and clinicians have a duty to analyze medical interventions through a careful risk-benefit analysis to consider the potential positive and negative effects an intervention may bestow on a patient. The healthcare system, trained under vastly different principles and codes in the correctional system, should strive to function free from bias regarding a patient's criminal history in the name of beneficence and non-maleficence. And finally, the principle of justice asserts an obligation to be fair in the allocation of the benefit and burdens of society. The AMA Code of Medical Ethics states that differences in treatment that are not directly related to differences in individual patients' clinical needs or preferences constitute inappropriate variations in healthcare, which may specifically contribute to worse outcomes for minority populations. Therefore, the ethical principle of justice supports care teams providing competent and comprehensive care for all patients, regardless of their status within the correctional system. So let's take those principles we discussed in the previous slide and apply them to the framework for capacity. So we know that capacity allows for the ability to make decisions for oneself. A determination of capacity is evaluated by an individual patient's ability to understand information relevant to the decision, appreciate and apply that information to oneself and situation, reason and manipulate that information rationally, and finally, to express or communicate a clear and consistent choice. All 4 of these factors are required. So we all know that some decisions take far more cognitive processing than others. So making a choice of what I want for dinner tonight is far easier than reasoning through the risks and benefits of 2 treatment plans that are available to me. So you can see how a patient may have capacity to make one decision for themselves, but not for others. When a physician determines a patient lacks capacity or is otherwise unable to make medical decisions on their own behalf, a surrogate or proxy decision maker may assist in healthcare decisions for that patient. We will dive into surrogate or proxy decision making in a few minutes. But one thing we must remember, and this can be difficult at times, is that capacity is not overarching or all-encompassing. So while we're discussing capacity, 2 words that are often erroneously used interchangeably that have distinct meanings are capacity and competence. While we could likely spend an entire lecture on how these 2 concepts can intertwine, we're going to stick to definition level here. Capacity, as we discussed earlier, is a medical term that refers to a person's ability to make a decision about a proposed medical treatment and an aspect of care. And this is determined by a physician. Competence is a legal term defined by the judicial system, and competence refers to a global decision-making ability, which includes finances, property, wills, and this is assessed by a judge in the court of law. So what do we do when we know that the patient lacks capacity to make decisions independently, but a decision must be made? Let's take a look at who may be considered by the medical team when discussing patients experiencing incarceration, while discussing the advantages and disadvantages to each. So when considering the use of family or friends, we must think of the regulations that limit visitation and privacy in the interest of security for this patient population, both when the person is physically located in the prison and in the hospital. These regulations can pose additional barriers to discussions that may result in meaningful conversations about values and preferences. This would warrant corrections and hospital staff collaboration to ensure access to allow for meaningful conversation, while at the same time ensuring the safety of the patient, correctional staff, and our team members. Advantages to these groups include the fact that family and friends typically do have knowledge of the patient's values and preferences for their loved ones. However, in this population, there can be an increased risk of estrangement, which may lead to these decision makers maybe not having updated information in this regard. So this may lead you to think about, what about a friend who is also incarcerated? Because of the innate social isolation that prisons create, incarcerated individuals have an opportunity to make lasting relationships with others within the correctional system that may foster communication regarding morality and individual beliefs. Although state and federal law does not overtly exclude other incarcerated individuals from making medical decisions for other prisoners as a friend, this is explicitly prohibited by the Federal Bureau of Prisons. My best advice for these unique situations would be to work closely with ethics consultation services to ensure the appropriateness of this arrangement, because it can be complicated. Correctional clinicians could include staff physicians, mental health specialists, chief medical officers, or another designee that has medical training within the correctional system. While these potential decision makers may have sophisticated medical knowledge and training, there is likely a lack of understanding regarding the individual patient's true values and preferences, potential conflicts of interest, and medical resource considerations that could play a role into their motivation. Lastly, wardens or prison officials are similar in this regard. A warden has presumed proximity to the patient and known decision-making authority over other aspects of the patient's life, and therefore often becomes a default for hospital clinicians to defer to for medical decisions. The disadvantages to this heavily outweigh the advantages when considering that it is ethically in the best interest of the patient. Wardens have a significant conflict of interest for financial, resource, and security reasons. Some states, not yet Indiana, have moved to avoid these conflicts of interest by barring prison officials from serving as a medical decision maker. So next we're going to take a look at the legal analysis. Luckily, the law with respect to autonomy of patients experiencing incarceration mirrors much of our ethical analysis. Specifically, the Supreme Court holds that prison walls do not form a barrier separating prison inmates from the protections of the Constitution. Although it is a common misconception that incarcerated individuals lose their right to self-determination, people who are incarcerated retain some constitutional rights. This includes an Eighth Amendment right against cruel and unusual punishment, the due process right to administrative appeals, protection under the Equal Protection Clause of the 14th Amendment, and the right to freedom of speech and religion as long as it does not interfere with their status as an inmate. In Estelle v. Gamble, a landmark case from 1976, the Supreme Court held that depriving incarcerated individuals of reasonably adequate medical care violates the Eighth Amendment. So what does this mean? Put simply, only one group of people in the United States has a constitutional right to health care, and that's citizens experiencing incarceration. Prison authorities who delay or refuse medical care, causing pain and suffering, or physical torture or lingering death, have been found to be in violation of the Eighth Amendment. In addition, the choice to treat in a manner that is easier or less efficacious than the care actually necessary is now also deemed a violation of a person's rights. Another important point I want to make is that these individuals also have the right to not participate in unwanted health care. The Due Process Clause of the 14th Amendment and common law have generally permitted individuals experiencing incarceration to consent to or to refuse medical treatment in the same way that those who are not incarcerated are able to do so. As you can imagine, there can be tension between a state's duty to avoid cruel and unusual punishment and an individual's liberty interest in avoiding unwanted health care. Therefore, the right to health care is not absolute because deference is given to state actors in prisons to make and implement policies that ensure maintenance of safety and security. I may have done something. There we go. So as far as application, when looking at whether an Eighth Amendment violation has occurred, courts have agreed that a prison official may be held liable for acting with deliberate indifference if they know that, one, the prisoner faces a substantial risk of serious harm, and two, that official disregards the risk by failing to take reasonable measures to abate that harm. When courts are determining whether the prison is imposing on a constitutional right of a person experiencing incarceration, the standard is whether the prison action is reasonably related to a penological interest, using a rational basis test. Now, without getting too far into the weeds, the best way I can describe this is with a real example in which a court sided with a prison when presented with the question of whether the prison could force dialysis because the patient's refusal was not related to his wish to die, but rather as an act of protest to be moved from a moderate level of security to a minimum level of security. The court stated that the prison's interest in maintaining the order of the prison overrode the patient's right to privacy and their choice of health care. Courts are typically reluctant to interfere with the normal process of prison administration. However, precedent confirms that they will not hesitate to intercede to protect a constitutional right. For example, in 2018, the 11th Circuit Court of Appeals held that a prison warden was not entitled to qualified immunity after calling for hospital staff to enter a DNR order for an incarcerated patient when transferred from the prison to the hospital. The patient required hospitalization after he was stabbed in the eye by another inmate. The warden demanded no heroic measures be taken despite the incarcerated patient's mother insisting continuation of life support. The hospital removed life support, resulting in the death of the incarcerated patient, and erroneously stated that the decision to terminate life-sustaining measures belonged to the warden because the state had legal custody over the incarcerated individual. The court held that the warden was not entitled to qualified immunity because his alleged actions were not within his discretionary authority. So in summary, people experiencing incarceration generally have a constitutional right to reasonably adequate health care, but can be constrained only by legitimate penological interests of the Department of Corrections when attempting to further safety and security. A couple more legal slides. All right, so we're going to take a look at the state picture. Indiana assumes that an adult has capacity. This means that all individuals, including those who are incarcerated, are presumed as having capacity until our capacity is reasonably called into question. The section of Indiana Code we're most concerned about for the purposes of this lecture is Section 5. This section provides legal authority for healthcare decision-making through a non-judicial rule of law when no guardian or agent has previously been appointed. This section probably looks familiar to most of you, if I had to guess. This section allows for physicians to consult a proxy to communicate the patient's health wishes and provide informed consent or refusal to propose healthcare interventions. We utilize this hierarchy for all patients who are incapable of consenting for themselves and do not have predetermined healthcare representatives. You will notice who is not included on this list, and that is a warden or a prison official. Indiana does not currently have statutory instruction to defer to a warden in the event of an incapacitated patient experiencing incarceration, and therefore wardens should not serve in this role. Again, at this time, Indiana statute does not contain specific language for incarcerated individuals in regards to who can and cannot make medical decisions. Therefore, Indiana's default surrogate decision-making statute serves as a rule to guide designation of a surrogate decision maker for incapacitated patients experiencing incarceration. So next we are done with the law, and now we're going to take a look at IU health policies that are relevant here. All right, so here are 3 relevant IU health policies that refer to the provision of care for our patients who are currently incarcerated. So prisoners' provision of services to forensics is an AHC policy that largely pertains to the safety, scheduling, escorting, and transportation of patients who are incarcerated. This policy does specify that prisoners may not have visitors during their stay at the hospital, with exceptions made for patients who are terminally ill or documented as high morbidity and mortality. This policy also states that all patients experiencing incarceration will be designated as non-disclosure or a no information patient. Please check to see if your region has a specific policy for these instances, as this one does apply to AHC. The no information status patient is a policy that ensures no information is provided to any person who is not directly involved in the patient's care. This policy specifically refers to forensic patients as a patient who is a prisoner of a local, state, or federal prison, and states that the identified prison or jail caregiver is considered as being directly involved in patient's care, thereby allowing the flow of communication regarding the patient's status to be received by law enforcement or correction officials. However, this policy has been inaccurately interpreted as barring any communication between clinicians and the patient's appropriate surrogate decision maker. And when I started this work back in 2019, the policy for patient consent for clinical services looked very different than it does today. So a new revision of this policy now explicitly provides guidance for our team members in the arena of patients experiencing incarceration. And honestly, I could not be happier. So I don't love to read verbatim, but I think that this is really important. An adult patient with capacity who is brought to an IU health facility from a jail, prison, or a mental health facility, whether in custody or not, has the same right to make decisions about his or her care as any other adult with capacity unless otherwise ordered by a court. And for prisoners, arrested persons, or institutionalized adults without capacity, supporting the Indiana Code we discussed earlier, patients experiencing incarceration without capacity encounter the same process for determining a decision maker as all other patients who do not have capacity. This means we look first to an appointed healthcare representative, and second, to the statutory hierarchy to determine who would be the appropriate person to make decisions. Now, this policy completely and accurately summarizes the ethical and legal framework we have discussed in previous slides, treating patients experiencing incarceration as having the same legal and ethical authority as those who are not for proxy decision-making purposes. So if you're a visual person like me, having a flow chart is helpful when guiding decision-making. So starting at the top, I know that the people in the room can't see all of that, but it does say, does the patient have decision-making capacity? And that's always going to be our first question. If yes, the patient provides consent for themselves. If not, we next ask whether the patient has a valid advance directive. If yes, we determine the decision maker from the advance directive. And if no, we ask if a default surrogate, according to the hierarchy we talked about in the Indiana Code, is willing and able to make medical decisions for the patient. If yes, we rely on the most superior default or proxy surrogate decision maker. If there is no available or willing surrogate decision maker, we may need to explore the court-appointed guardianship process. And I put down in a window at the bottom that there is an exception for urgent and emergent needs. Physicians should act in the best interest of the patient. So back to James. Thinking back to the case study presented towards the beginning of this lecture, let's go through the potential decision makers to consent for James' paracentesis. So can James consent for himself? I see a lot of head nods. No. Unfortunately, because of his altered mental status and current lack of capacity, we are going to have to move from the first bubble. So does James have a valid advance directive appointing a healthcare representative? Unfortunately, no, he does not. So we'll move further down the list. So what do we know about his social circle? We know that James has an ex-wife. We know he has a mother, and he has a brother. The ex-wife no longer holds a designation as a spouse, and therefore should not be considered as such. James' mother could be a consideration, as she would come next on that statutory hierarchy. However, if she is unavailable or unwilling, either because of their estrangement, lack of understanding of James' values or preferences, or if we're just unable to reach her, we would next default to James' brother, who has maintained contact with him as an adult sibling. That would be assuming that he's over the age of 18, which wasn't mentioned back in the text earlier. If James' brother is unwilling or unable, the team could look to a friend of James that has current knowledge of his health, values, and preferences, and maintains regular contact with James. So I'll ask the question, should a warden consent? No. Given the factors discussed during this lecture, the warden should not be considered as a default decision maker. What about the physician? In urgent and emergent situations, physicians should be empowered to use a best interest standard to provide life-saving or sustaining treatments and intervention. However, in the context of a non-urgent procedure, physicians should not be asked to fill the role of a default decision maker for this patient. And if all outlined possibilities fail, a court-appointed guardianship should be explored to consent for the procedure and further serve as default decision maker for future healthcare decisions. Makes it look so easy, right? So lastly, we're going to end on just communication and recommendations in general. So while communication challenges between acting or potential surrogate decision makers and hospital staff have always been complicated given security reasons, this was especially highlighted during COVID-19. For quality care, it is vital for surrogate decision makers to be guided by the patient's values and goals, which is why it is important for communication to be routine and meaningful, if at all possible. Providing information regarding the location of the incarcerated patient to surrogates may be thought to lessen the incarcerated individual's safety and or the safety of the prison system itself. However, incarcerated individuals' right to be afforded informed decision-making from either an individual assigned by an advance directive or through the Indiana statutory hierarchy requires an adequate level of communication to ensure that that surrogate is informed of the medical status and pertinent information communicated by the medical team. The medical team and prison staff should collaborate to determine the least restrictive course and volume of communication to achieve the safety interests of the prison official, coupled with the interest of the incarcerated patient to receive the opportunity to have an informed decision maker. The amount and type of communication may vary based on the individual scenario of the patient and will need to be considered on an individual basis. So ending on a preventative or proactive note, think of how the complexity of these challenging situations could lessen if during or shortly after intake, individuals experiencing incarceration could be encouraged to complete and regularly update advance directives to elect an appropriate default decision maker in the event that they may need one in the future. And most importantly, the challenges of determining decision makers is not isolated to patients experiencing incarceration. I think everyone that served on an ethics consultation service would agree with me there. There should be a greater emphasis for all people to complete advance directives to avoid a situation in which a patient's care is challenged in the event of incapacitation by the determination of who would be the best person to provide guidance for medical decision making. The recommendation, first one, to contact the ethics consultation service if your team finds themselves providing care to any patient, including those who may be incarcerated or unbefriended, in which consent issues arise. And number two, with patients with capacity, medical providers should continue to be empowered to treat incarcerated patients with an uninterrupted standard of care and allow for incarcerated patients with capacity to make their own healthcare decisions. Because we all know that things can change on a dime, the medical team is encouraged to seek information regarding potential surrogate decision makers in case the patient's health status declines to the point of incapacity. And for patients without capacity, the medical team must first be able to rely on prison officials to provide reasonable information regarding the patient's potential or confirmed surrogate decision maker. Second, we must rely on assistance for regular, timely, and informative communication to allow for the surrogate decision maker to be privy to reasonable updates to inform healthcare decisions. If an advance directive was completed prior to incarceration, this should be considered valid and upheld. IU Health should engage the Indiana Department of Corrections to obtain available information regarding an incarcerated individual's written advance directive and or the name and contact information for a healthcare decision maker. In the event a proper surrogate decision maker cannot be located for an incapacitated patient, IU Health shall seek options to obtain a court-appointed guardianship if that's necessary. I hope that we can all agree that this work aligns with the vision, promise, and values of IU Health. Our vision to make Indiana one of the nation's healthiest states includes all Hoosiers, regardless of their status within the correctional system. We promise the best care, individually designed to fit the needs of each of our patients with unique needs. I hope this presentation provided a clear framework to begin to critically think how we can provide excellent and compassionate care to patients who arrive from correctional facilities. Every single patient we encounter has a unique story, and I am optimistic that we can provide uninterrupted care in line with each patient's beliefs and values. Thank you so much for your attendance and attention today, and I will now open the floor for any questions.
Thank you, Allie. Everyone online, thank you for your patience as we fixed the echo earlier. I appreciate it. I do have a couple questions that are online, and I apologize if you did touch on these already. Are there differences in policy and procedures for the care of the incarcerated by the incarcerating entities such as local, state, and federal?
Local, state, and federal. So I did touch a little bit on this is a very distinct part of the presentation, but for the friend serving as a default decision maker under the Indiana statute, that one can get a little complicated because Federal Bureau of Prisons has said absolutely not. Another incarcerated individual cannot consent as a friend, but state has not, to my knowledge, had any guidance on that. But other than that, we would treat state and federal patients that are incarcerated in the same manner.
Hold on, Rebecca.
So kind of piggybacking on that, if a person's surrogate decision maker is their mom, and the mom is incarcerated, and so they absolutely cannot based on those laws, or they can. I mean, clearly it's a web. Yeah.
I mean, we would need to delve into that quite a bit. It doesn't seem as though if the patient were in state prison that would be an issue, but federal it may be. So it would just take a lot of research, but I'm not 100% sure, but I feel as though they probably could consent on the basis of the Indiana statutory hierarchy, but unclear. Good question. And a lot of this is individualized. I know that we've talked in situations that we have encountered within the ethics consultation service, and every situation is different and unique, and requires quite a bit of deep dive sometimes.
Okay, so I'm not sure when this one came in and what part of the presentation it was. I assume, because this person says, I assume that these things apply in the jail as well, ... no warden. Okay. But the next part of that is what can be done when law enforcement tells staff that family cannot be contacted due to safety?
Yeah, so that's going to be part of that penological interest analysis that was within the legal analysis portion. There's going to have to be a discussion between our staff members, Department of Corrections staff members, to determine what the individual level of safety and security is for this patient and what we can do to try to critically think and problem solve through those things. Because I understand that each patient situation is different, and if there's violence and there's concern for that to happen, then we would need to address that on an individual basis. But all in all, it's going to take a lot of collaboration.
I wish I'd had this talk before I was the on-duty ethics consultant. If a prisoner was a patient and had capacity, could they complete an advance directive outside the prison, which would then be valid and could be upheld because I mean, I'm guessing yes, based on what you said, but I want to hear your thinking.
So let me make sure I understand that. The current person who's incarcerated, who signs their own advance directive.
But while they're with us, while they're a
with
patient,
us. I don't. At top of mind, I don't see any problems within that because they still have the right to consent to their own healthcare, and determine those, because we would, if they didn't want who was gonna be part of their Indiana statutory hierarchy that we would default to, I assume that we would allow them to sign. I can't think of any reason as to why not. But I can get back to you on that because I do want to make sure I have a firm answer.
All right. We've had some confusion related to patients who are on work release and what the policy is. Will you provide some clarity on this?
Work release, I am unsure, but I don't think that we would even take that into consideration. And the reason I say that is because I'm unsure we would know that for a number of our patients could be on work release, without us having knowledge of that, and we would not provide any different care. So it depends on what the care would be, I guess, but I don't see a problem there either, because I think that could happen to any number of our patients coming through the door without our knowledge.
All right. We have a number of questions online, so I'm going to keep going.
Okay.
Okay, great. Is anyone contacting our Indiana prisons to get their cooperation and providing the contact information for surrogates, et cetera?
Yes, so without disclosing too much, I mean, we've had recent situations in which there's been a very collaborative approach. And so I know that the ethics service has been working with the Department of Corrections to be able to build those relationships.
As a forensic nurse, I have been told we are not able to contact the family of a no info patient. How would we get a hold of a decision maker?
So, can you read that one more time?
As a forensic nurse, I have been told that we are not able to contact the family of a no info patient. How would we get a hold of a decision maker?
And now going back through the IU health policies for no information patients, I know I stated that it sometimes has been erroneously, used to say we are not able to contact family members, but if they are the healthcare representative for that patient, we are going to need their guidance in terms to be able to provide healthcare for them. So, I mean, I can try to, I don't know if that's something that you could we contact ethics consultation service and try to work through for department reasons, but that sounds like a good opportunity.
Thank you. If the patient surrogate has made if the patient surrogate decide on a medical course that is expensive, wouldn't the correctional system refuse to pay for such care?
That one's a little bit difficult as well. So you guys are really feeding me the tough ones today. And I had a feeling that would happen because we know that these situations are complex and really tricky. So that was part of the reason why we discussed who would be an appropriate decision maker for these patients. Because as we can imagine, the motivation to not pay for a very expensive life prolonging treatment could be highly motivating for some. And so that's why we wouldn't necessarily ask that person for healthcare decision-making reasons. Now, I am no expert on how healthcare is paid for through the Department of Corrections, and so that's something that I would not really be able to answer.
That is all the ones online at the moment. Does anyone else in person have a question? No? Oh, one just popped in. FYI, in the federal prison culture, prisoners are told by other inmates not to complete advance directives since an advance directive will compromise their healthcare system while in prison.
Will compromise, say that again?
Will compromise their healthcare while in prison if they complete an advance directive.
Here, if the person could elaborate, if they have time.
Yeah,
I'm curious to hear more about that.
I would be too.
don't have much to add. I would hope that people would feel empowered to list somebody on their healthcare rep form that they trusted to make those decisions for them instead of relying on, obviously, the complexities of who may be asked, especially in a healthcare system that is maybe not used to encountering these patients quite as often too.
Another one did ask, at the end of life, does the prison provide consents for visitation?
Yes. Well, I'm sorry, does the prison provide consents for visitation? I can speak to the IU health policies that we do allow for end of life visitation as per our policies that I went over in the lecture. Okay, next question. Uh-oh.
Okay, how do those end of life visits get coordinated?
That was something to be worked through. I'm just gonna spitball here, but I would think social workers are really great at working through these situations, and so I would work through social work staff.
This is somebody from Eskenazi asking, and so I didn't know if we had that I might connect you with to see. Well, I know you had just referred to the social workers, but somebody else that might have an interest. Amy apparently remembered her question and better remember it by the time I walk back down.
Can you speak a little bit about disclosure of information, right? If the warden in particular isn't necessarily the decision maker and appropriately should not be, how much information that would be maybe HIPAA protected or privacy related do we disclose to the warden, or how much are we obligated to?
I would say minimum necessary. I mean, I kind of.
Minimum necessary for what? Like, what would your standard be? How would we think about that?
I would think about it in the way of needing information for things like discharge planning, things that they would have to be able to plan and work through. And also any information that we would need to receive from them about default decision makers, contacts, those types of things. But as far as just kind of speaking off the cuff, I think outside of discharge planning and surrogate decision making, I would take a minimum necessary standard.
I can add to that just a little bit, just speaking for some of the case managers I've worked with. Yeah, they will communicate with oftentimes the prison clinicians that they have on staff. So they'll more often communicate with them rather than to the warden, just for discharge continuation.
Thank you.
Hi, Allie. Good job. As you know from our last conversation related to this, sometimes the wardens are designated as the legal guardian. So can you talk a little bit about how then, like how that affects like your thoughts about this whole process, and how frequently have you encountered either literature on that or scenarios where that is the case?
Yeah, so not often, but it has happened that the warden has been named as almost like a guardian for a patient that has been deemed incapacitated. So, and it has worked in the past, actually has been really successful in collaboration, that the warden was named by a judge. And so there's not a lot that we can do there, because we talked about before. Now, if it's court appointed, and if the judge in the court appoints that the warden is going to be the decision maker for this patient, that is who we go to for those decisions. And it has happened in the past that has been a very fruitful and successful relationship in order to be able to provide a good standard of care for patients. And so when that happens, we get really excited, and we hope for better collaboration in the future, so that there's a good shared understanding between what our goals are and what their goals are, and how we can best serve our patients. So thanks, Christy.
Kind of a follow-up to Amy and Rachel, wouldn't the warden or the prison staff be the one who receives the discharge paperwork, or can it be given directly to the patient and kept privately?
As far as actual logistics of who the discharge paperwork would be handed to, I'm not sure I could answer that question.
And then I think we got time for one more here. A repeat question for clarification. If an incarcerated individual wants to make a healthcare representative while at the hospital and is decisional, how do we proceed?
Yeah, I didn't find anything in the literature, and I can definitely get back, that we would not allow for a patient with capacity to make that designation while they were in the hospital.
You mentioned when incarcerated patients can receive visitors. Again, as a forensic nurse, I've had an incarcerated patient request a victim advocate. I was told they were not able to have a victim advocate. Is that correct?
I'm not sure about victim advocates and what the program is. So I'm not sure I could speak to that either.
Okay.
But if they, I would say for safety and security reasons, if we haven't vetted who, there's a specific program that's receiving or, providing the advocate, there's a lot of complexities there. I'm not sure without having a conversation.
Sure.
Apologize.
Thank you, Allie, and thank you everyone in person and online. Just a reminder, in January, we do not meet the first Wednesday of January, so we will not have our next lecture until January 18th. If you do have questions about some of these more detailed things, please feel free to reach out to fcme@iuhealth.org and we will get you connected the best we can. Thanks, everyone.